Good morning, everyone. Good morning, everyone, and welcome to this next installment of our employment law webinars with Burness Paull. Thank you for joining us. My name is David Morgan. I will be presenting today along with my colleague Andrew Knight. Andrew's in Aberdeen. I'm dialing in from Glasgow. So a few housekeeping points. You'll have seen the holding slide. I know many of you are seasoned visitors to our webinars, and thanks again for joining us, and welcome if it's your first time. But we will keep you all in mute if that's okay. There's a large number of participants who've joined as delegates today, so to minimize background noise, we will keep you on mute. Feel free to submit any questions. There's a chat facility you can see with a pop-up speaker box. If you want to submit any questions via the WebEx chat function, and we'll try and get to those if time permits as we go along. Such as the scale of this, we won't take questions at the end, and we'll look to wrap up sharpish at 12 noon today. There have been some capacity issues, I understand, with WebEx as it's been used so heavily around the UK, but looks like everything's working technology-wise. We're online. If there's any break in the service, we'll send you a message and we can look at rescheduling. This session will also be running again next week on the 27th. And we will be recording this session so that those that were unable to join today who registered will have the opportunity to listen back with an audio version of the session. If you've got any queries about that, our privacy policy is available on our website. So without further ado, I will, if I could, just share my screen to have a look at what we are going to cover today. This is, in fact, a general update on employment law. This is not all about, for the first time, it's not all about COVID-19 and coronavirus, although we will, if time permits, look at covering some of the key issues there. But around this time of year, and I had to ask myself, what is this time of year? Is it February? Is it June? Is it September? I've lost track. But around this time of year, we would generally host a series of seminars and lunch and learn sessions with updates on employment law. So in lieu of that, what we decided to do was to utilize the webinar technology to have a good case update on recent and forthcoming employment law cases, an update on recent legislation, and again, touching on some future changes for the key things to be looking out for. And as I say, if time permits, we'll have a quick look at some of the latest on the COVID crisis and the employment law implications of that. So first up, I will touch on the first couple of cases that I wanted to cover. This one attracted a great deal of attention in the employment law community and also in the news media. Another of the emerging cases on employment status, this vexed issue of employment status. Be against Yodel Delivery Network, and this went all the way to the European Court on referral from a local UK employment tribunal. So it's the next in the series of so-called gig economy cases. We've seen Uber, we've seen Deliveroo, Pimlico Plumbers, but here's Yodel. Now, I think in lockdown, more important than ever, this industry, isn't it? Probably one of the busiest sectors of the economy, delivery drivers, and many of these individuals fall into a bracket of having limited, if any, employment protection rights. So this case involved a delivery driver of Yodel, which will be familiar to us all. And I often talk about employment status having three levels of standard, a gold, a silver, and a bronze standard. Gold being full-blown employment status, silver being a worker status, that middle bracket, and then bronze being a self-employed person who has far fewer employment protection rights. This case hinged, as many of them do, on whether this delivery driver at Yodel was a worker. And the background, and they're very fact-specific cases, but there's a lot of overlap with many of the cases that we look at. He had a contract, and that's always a starting point, that said he was self-employed. We know from all the case law, you need to look behind the contract to the practical reality. And importantly, at Yodel, he was allowed to appoint a substitute, although Yodel could veto who he chose. And recent cases have been pretty key that substitution is potentially fatal to a claim. Deliveroo was a case that said a right of substitution. This was a union recognition case that said, yeah, substitution will be a problem for getting worker status. The courier was liable for acts or omissions. He could choose the time of his delivery and the route that he went. And indeed, he could also work for other, even competitors. He could do other gigs, if you like, for other providers. Lo and behold, this was referred, as I say, to the European Court, and the European Court said that this right to engage substitutes, to appoint someone else to do the driving work, meant that he, in the view of the European Court, should not be considered to be a worker. And this was a case involving the working time regulations or working time directive here. So that was quite a key factor. The Couriers' independence, they said, did not look fictitious. And they will scrutinize the courts carefully what the practical reality is, as I say, more than just what the contract says. And this actually was, I think, a bit of a shift from a lot of the direction of travel of cases like Uber that we've seen, which tend to see pushing in the direction of there being worker status at least. But from the European Court's case on this particular one, they felt no worker status. However, it still is not over. This was a referral there, and it goes back now to the Employment Tribunal in the UK to make a decision on the facts as to whether they agree with this referral from the opinion, if you like, from the European Court. So that's employment status. I'll now touch on another very high-profile case that I'm sure you all saw quite curiously reported, not least in BBC, of course. This was Samira Ahmed against the BBC, and this is an equal pay case. So equal pay has really, I think, rocketed up the agenda for employers, largely on the back of gender pay gap reporting, which you'll recall introduced a few years back. Importantly, we all know, don't we, that gender pay reporting and equal pay are different concepts, but it definitely turned up the volume on equal pay when the gender pay gap report legislation was introduced. So what was once very much the domain of the public sector, again, huge volume class action claims in local authorities, predominantly female sectors such as care workers being comparing themselves with refuse collectors who are predominantly male, those glut of claims that clogged up the tribunal system, thousands of them, tended to be more, as I say, the domain of the public sector. And more recently, the next wave of equal pay litigation that we've seen has crept more into the private sector. So thinking about the financial services sector, supermarket chains, ASDA, under considerable litigation from the no-win, no-fee lawyer population, class action claims comparing predominantly female checkout assistants with distribution workers, predominantly male in that comparison. So media likewise, BBC were greatly in the spotlight in looking at their gender pay gap, which highlighted a number of individuals who said that they were paid less than their male comparator. Samira Ahmed, a high-profile presenter, identified that a male, Jeremy Vine, again, a very well-known presenter, was paid considerably more than her. In the order, I think, of about 6 times as much Mr. Vine was paid compared to Ms. Ahmed. And as the tribunal said, the difference in pay is striking. It was 6 times for doing what the question was the same work. So equal pay, a very complex area of legislation, but put simply, what it does is a curious novelty of the law, and it says that if someone of one gender, in this case a female, can find a actual male comparator who's paid more than her, the law implies what's called a sex equality clause, an implied little mysterious clause featured in every contract of employment, such that if she can show that there's a male who's paid more than her for doing the same or broadly the same work, like work of equal value, and there's no defense to it as justifying that for what's called a material factor other than sex, then this mysterious pay equality, sex equality clause will up her pay to the same level as her comparator, in this case, Jeremy Vine. And that is, in quite a damning judgment, exactly what the London Central Employment Tribunal held in the case of Samira Ahmed. They could find no evidence presented by the BBC to justify the difference in their pay. Probably one of the most reported quotes that hit the tabloids was it being said that Jeremy Vine had a glint in his eye with a cheeky presentation style, which apparently justified six times as much pay compared to Samira. But in evidence, what came out was they were scripted. All of the presentations were scripted by producers and editorial teams, and they spoke from an auto cue. So there wasn't, I'm afraid, in the BBC's defense sufficient to justify that pay differential. It's a case on its facts, of course. It's an entry-level employment tribunal decision as well. However, I think it is a timely reminder on the back of this volume being turned up on equal pay to remember the importance of pay transparency, to be able to have an evidence, a paper trail, if you like, of clear pay structures that are untainted by sex, and to be able then, in the event of a dispute, actually to justify where the pay differential may be as being unconnected to sex. So we definitely are seeing more equal pay litigation, not just on the class action, but I think many more claimants being prepared to put their head above the parapet if they believe that they are being underpaid compared to a colleague of a different gender. And I'll hand over to Andrew now to look at the next area of holiday pay.
Hello, and thank you, David. So, turning now to holiday pay, I expect that most will be familiar with the now very well established principle, that for the first 4 weeks of holiday in each leave year, certain elements, variable elements of pay, such as overtime, commission, may need to be taken into account in the calculation of holiday pay. This has been settled law for a few years now, but when it was first decided, it created quite a bit of a stir, as it appeared to contradict the plain wording of the UK legislation, which seemed to permit holiday pay to be calculated on base pay only. This in turn led to a vast amount of litigation, with workers looking to utilise our unlawful deduction from wages legislation to make claims for underpayments of holiday pay, stretching back over a number of years. In very broad terms, the unlawful deductions rules allow workers to claim for a series of deductions, provided that the claim is lodged within 3 months of the last in that series, allowing for any extension of time for ACAS early conciliation, of course. So 2 things happened to help stem the flow of claims. Firstly, the UK government brought into force regulations which provided that claims could only go back 2 years, and those remain in force, but they didn't affect claims which had already been submitted to the tribunal, so were already in the system before the point that the regulations came into force. So any claims lodged pre-1st July 2015 weren't limited to going back 2 years. The second thing that happened to kind of curtail these claims was that the Employment Appeal Tribunal held in the case of Bear Scotland and Fulton that if there was a gap of more than 3 months between underpayments in a series, then a claim could not be made in respect of any of the earlier underpayments prior to the 3-month gap. So I appreciate that's not entirely straightforward concept. So to illustrate with an example, if I'm underpaid for a holiday on the 25th of January, the 25th of June, and the 25th of July, and I lodge a claim on the 25th of August, well, I've lodged my claim within 3 months of the last deduction in the series, so my claim's in time, and there's no gap of 3 months or more between the underpayments in July and June. But because there's more than 3 months between the underpayments in June and January, I can't claim in respect of the January underpayment or anything before that. So this was a very helpful decision for employers, but one which appeared to be based on public policy grounds rather than anything in the legislation. And that decision survived for a number of years. However, last year, the Court of Appeal in Northern Ireland held in the case referred to on the slides, Chief Constable versus Agnew, that the decision in Bear Scotland was wrong and that a gap of more than 3 months between a series of underpayments did not break the chain in this way. It's important to say that the decision of the Court of Appeal in Northern Ireland is not binding on the rest of the UK. However, reasonably hot off the press, in March this year, permission for the Chief Constable to appeal that decision to the UK Supreme Court was granted, and the decision of the Supreme Court could well have binding implications for the position in the rest of the UK. So one to watch, and one where, previously there was a bit of leeway for employers because of this 3-month gap rule that may not survive the challenge of the Supreme Court. So just passing back to David there.
Thanks, Andrew. Thank you. Moving on to another area that certainly we've lived with for quite some time, and it's interesting to see how the case law is still coming through on cases involving social media misuse, social media abuse or misuse in the workplace. So a couple of cases I wanted to touch on there that I think show a developing approach and a developing normality, if you like, around the use of social media and what can go wrong with it. The first involved London Heathrow Airport. Mr. Forbes was the claimant there. And again, they tend to have pretty inappropriate or salacious facts, don't they, to what daft things people get up to online, and particularly as they post a hasty Facebook or tweet message to all and sundry. This was a Ms. Stevens. Now, in her wisdom, she posted on Facebook, on her personal Facebook page, a picture of a gollywog. And she tagged to that, "Let's see how far he can travel before Facebook takes him off." So I think it showed that she knew it was a potentially inappropriate and often, it could be said, inflammatory message that she was posting, and presumably did this, as she thought in her wisdom, for some fun. As it happened, as always the way these things, it's a personal account, but one's friends often include their colleagues, and true enough, a colleague spotted this and showed it to Mr. Forbes. Mr. Forbes, I think, was all of an ethnic minority group. He was unhappy and offended by this and complained. And he complained about what he described as racist images being shared in the workplace. Ms. Stevens was disciplined, and I think it seems to me the right outcome was reached in that she apologized instantly, saw the error of her ways, and she was issued with a final written warning. Now, if that's all that happened, we probably wouldn't be talking about this case, and it would have been contained with probably a relatively fair and reasonable outcome. However, in their wisdom, what the employer did is, down the line, they ended up posting Mr. Forbes to work alongside Ms. Stevens, the person that he had complained about. And he wasn't happy with this, as you'd imagine. He complained, I think put a grievance in, asked for a move to another location, which was rejected. And lo and behold, he went off sick and eventually, as you'd imagine, brought a claim for harassment. Now, discrimination claims, who's he going to bring it against? Who's got the deeper pockets? He's going to sue the airport, isn't he? So he brought his claim against the airport and tried to found upon the principle of vicarious liability. So was the test then for the tribunal and ultimately the Employment Appeal Tribunal was the behavior of Ms. Stevens in the course of her employment such that London Heathrow Airport should be found vicariously liable for her wrongdoing. So thinking about in the real world, not the online world, that might be a Christmas party, the extension of the workplace. That was effectively what the tribunal had to wrestle with here. Did her posting this inappropriate racist Facebook message amount to something in the course of her employment? Both the Employment Tribunal and the Employment Appeal Tribunal here said no. They found, in fact, that this was not in the course of employment. They did say, of course, it's a question of fact, but this was, in the view of the tribunal, on the facts, a personal message she made on her personal Facebook page. It didn't relate to work on any view, did it? It wasn't a work-related posting. And in this particular case, even though there were some work colleagues in her friendship group, if you like, on Facebook, it was held that this was not in the course of employment. Now, again, I'm not sure we read overly too much into that from a risk management point of view, because the tribunal and EAT did say that there will, of course, be circumstances. They gave some guidance for when an act done would be viewed as in the course of employment. And this would be, let's say, if there was a Facebook group or a page that was dedicated, say, to colleagues of London Heathrow, and she were to do it there. We're all living now, aren't we, with group texts and chat rooms and such like on WhatsApp. And if something inappropriate were to have been posted there I think would be a good example of taking the personal into the workplace, and thereafter, of course, potential liability for discrimination. So the EAT did say there are occasions they could view where something could be so closely connected to the workplace that it's enough to render it relevant and potentially liable for the employer. Because as we've all learned to come to terms with the technology and the employment and HR implications, I think there's probably two key themes that I would summarize in dealing with over the years advising on cases involving social media misuse. And the first is, and it touches on the next case I'll come to, but the first I've always said is that employees should have no expectation of privacy when they're on social media and when they're on online sites. And I think that's a good point, isn't it, as it relates to Ms. Stevens. She posted that on her Facebook page, but you've got to remember that what goes on online stays online, and even if it's within her private circle of friends, all it takes is one person who's in her network to print it off and to show a copy of it to HR. So employees, I think the tribunals and courts have been pretty firm on this. With social media, do not expect to be allowed an expectation of privacy. The old excuses of, oh, sorry, I didn't realize that people would have seen that, tend not to fly, as judges have got so much more familiar with dealing with social media. And the second lesson I always say to HR practitioners is don't overreact. Don't throw out the window your years of practice and guidance on good disciplinary procedures, i.e., what's common sense? Was that reasonable? Don't overreact because something happens to take place on an online environment as opposed to physically sending someone a message or a letter or a memo back in the day in the workplace. And actually, that's where I think the response here was probably a rational and a reasonable one from the disciplinary perspective in issuing a final written warning, largely because the individual was mortified, apologized, and said that she would apologize to Mr. Forbes. So there's a couple of themes which then takes me to the second case on the screen, which I'll touch on briefly. It involved the police service and had to go to court as a result of that. Police officers cannot claim unfair dismissal in the tribunals. They can claim discrimination. But as office holders, this was a case involving a conduct investigation into a police officer, and the evidence in question was found on a WhatsApp group. So there were group chats amongst a number of officers. We didn't see what was actually said, but they were characterized as sexist, degrading, racist, anti-Semitic. The whole host of protected characteristics seem to have been featuring in these inappropriate WhatsApp messages. And what the officers who were under investigation tried, and they had to go to petition the Court of Session in Edinburgh, this is a Scottish case, in order to protect their interests, was they tried to argue the right of privacy, the human right, Article 8 of the European Convention on Human Rights. They tried to say the respect for private and family life was engaged, and that these WhatsApp messages were private and should not be used in the course of the investigation. And what, interestingly, the court was asked then right at the outset to opine on was, Is there a right of privacy? Does a right of privacy even exist? And I think highly relevant as we all live and work with WhatsApp in the context of WhatsApp. And the judge found, the first instance judge found, that an ordinary member of the public using WhatsApp could have a reasonable expectation of privacy there. However, unlike the general public, in this case, police officers, they, in the eyes of the judge, have a higher standard and they're subject to regulations, the conduct regulations here, integrity, honesty, these concepts, codes of conduct, if you like. And in their case, the judge held that they shouldn't have the same high level of expectation of privacy. And therefore, the court allowed these WhatsApp messages to be used in the context of the investigation. Now, as it relates to, dare I say, all of us ordinary members of the public, if that's who the learned judge was speaking about, those that work in the world of work, I think that does potentially, this case, pave the way for a suggestion the likes of WhatsApp might be more protected. I'm a bit surprised by that, I have to say, and I think the way that the case law has tended to go, particularly with social media cases, Facebook, Twitter, Instagram, etc., that, look, don't expect them to be treated privately. Maybe the difference here is WhatsApp is an encrypted service, it's a private messenger service, but I still would exercise some caution here with this, in the sense that if you, as part of a disciplinary investigation, uncover inappropriate WhatsApp messages, you're not hacking into them or anything like that, but they're there in evidence, I don't think that there would be a challenge in using that in the context of a disciplinary, particularly if they were shared amongst a group of colleagues. And I think it does underline then, and you know, you've heard us say this for many years now, it underlines the importance, in this case, of having a social media policy, of having a written consent, if you like, for employees to have, particularly if they use a work phone. I had a case involving sexual harassment just the other month, and it was a work device. That was where the individual had a problem because he used a work device for sending inappropriate messages. And I think just underlining, as I say, that importance of having the right in writing in a policy to access and to use these messages, because, as I say, there was a slight shifting in the dynamic according to the court in the Police Scotland case. Actually, just quickly before I pass on to Andrew, I see a question on the chat function on that. Does it make a difference if WhatsApp's on a work device? I think absolutely. I think if it's on a work device, now I think the challenge with WhatsApp is it is highly encrypted, very difficult to access. But if it was on a work device and you had access to it as the HR team, this is a device that is provided to workers for work purposes, and there's an element, I think, of helm endu if you use it for inappropriate use and it becomes accessible. So you wouldn't be able to hack in, if you like, or to force your way into it, but if it was on a work device, I think it does make a difference. So thank you for that question. I think that is a good point to make. Thank you, and I'll pass on to Andrew to look at grievances. Andrew.
Thanks. And just picking up on your good practice, David, I see another question's come in on holiday pay, so I'll just deal with that quickly, try and keep that very brief before I move on to the next section. So the question is, do you have to use average holiday pay for the 4 weeks or 5.6 weeks as a minimum? So the question picks up correctly that there's a distinction. In the UK, workers are entitled to a minimum of 5.6 weeks leave. 4 weeks of that stems from the European Working Time Directive, which requires that as a minimum, and 1.6 weeks is the additional amount that the UK has decided to afford to workers. And you're absolutely right that the majority of the cases deal with that European leave, so the 4 weeks. So the cases that we talk about when we're saying, you know, you need to take into account potentially overtime, commission, etc., that relates to the 4 weeks leave. But I would just say it's not an entirely straightforward position in respect of the 1.6 weeks, because the 1.6 weeks refers back to our own domestic legislation on week's pay provisions, which are themselves complex, there can be certain circumstances in which you need to take into account some elements of variable elements of pay. Probably too complex to get into that, a whole topic itself, I think, but just to answer that one as best as I can. And then moving on to the next hot topic of post-termination grievances. So an issue that commonly arises for many employers is how to handle these. And to date, the legal obligations have not been entirely clear. In particular, the ACAS Code of Practice on disciplinary and grievance procedures doesn't deal with this point directly. And as a result, many employers have quite reasonably assumed that they have a degree of discretion in terms of how such grievances are handled. Often, employers will adopt a commercial approach, perhaps do a brief investigation of the issues without offering the employee a grievance hearing or right of appeal. And after all, the considered thoughts are, well, what difference does it make if the employee is already left? Any action or inaction by the employer at that point surely can't affect its liability in relation to the employee's departure. Well, that was certainly what was understood to be the position until the recent case of base children's wear mentioned on the slide. So just as a background reminder, you'll be aware that in certain cases, an employment tribunal is entitled to make an uplift in compensation of up to 25% where the employer has unreasonably failed to follow the ACAS Code of Practice. And in the base children's wear case, the employment tribunal found that the damages awarded to an employee in respect of a race discrimination claim should be uplifted by 25% as a result of the employer's failure to deal with the claimant's post-termination grievance. So it was an employment tribunal decision. However, it was appealed to the employment appeal tribunal, but on another point. So the respondent didn't even consider it worth appealing on this point. And indeed, in the employment appeal tribunal's judgment, it didn't pass any comment to suggest that the tribunal's decision was wrong in regards to the post-termination grievance. So what can we take from that? Well, it might appear at first sight that from this, it would be safest to always follow the ACAS code in respect of post-termination grievances. However, there may still be scope to follow a more simplified or truncated process in certain circumstances. For example, where the employer can be confident that the employee does not have any credible grounds for a claim, it may decide not to follow such a full process, because a failure to follow the ACAS code can't be made as a standalone claim. It has to piggyback on another claim, as it did in this case with the race discrimination claim. Just a kind of side issue to finish on in this section. The case also illustrates an important point that's often forgotten, and that's the risk of failing to follow the ACAS code when summarily dismissing an employee with less than 2 years service. It can often be thought, well, the ACAS uplift will only apply in an unfair dismissal case, and to raise an unfair dismissal claim, a claimant needs to have 2 years service, so we don't need to worry about the code. But this case underlines that ACAS uplifts can apply not only in relation to unfair dismissal claims, but also claims that don't require any minimum length of service, such as discrimination, whistleblowing, etc., provided that there's a disciplinary or grievance element to the case. So just a couple of important points to bear in mind there. And I'll pass back to David.
Thanks, Andrew. Next on the billing is philosophical beliefs. And again, I'm getting all the media interest cases. Again, there was a lot of stuff. It's fascinating, I think, seeing our own field of employment law and HR played out on the headlines, isn't it? And either TV or everyone seeming to have a view in society on the rights and wrongs of the work that we do. And this related to claims for potential discrimination. You've got an added head of protected characteristic on grounds of religious and philosophical beliefs. And just to recap, there were two cases, quite high profile, about vegetarianism and veganism. So a quick recap on what the law says about that, as to whether they are caught and whether they are protected on the grounds of religious, the recognized religions, or in this case, philosophical beliefs. These beliefs must be genuinely held by the individual. They must be a belief and not just an opinion or a viewpoint about something. They must be weighty, on a weighty and substantial aspect of human life and behavior. Again, this legislation came in at the same time as the religious discrimination, so you might see where that's weighty, substantial aspect of human life. They've got to attain a level of cogency, seriousness, cohesion, and importance, and be worthy of respect in a democratic society. An early case involved someone who is a member of the British National Party, and you can imagine his views. They were held not to be worthy of respect in a democratic society, and that individual was not protected as having that philosophical belief. So they don't need to be isms. They don't have to be certain isms or a fully fledged system of thought, but they need to have a certain status of cogency and seriousness to be protected. So over the years, we have seen cases involving beliefs in climate change. We've seen folks that do not believe in fox hunting. We've seen people that believe in the proper and efficient use of public money in the public sector, the sanctity of owning copyright. So quite weird and wonderful examples have featured. Quite wide arguments have been made around whether someone is protected truly with a philosophical belief. And here we have on the screen two cases. Topical, if any of you like me watched The Game Changers on Netflix and decided I'm never going to eat meat again, and then changed my mind a few weeks later. Picking and choosing vegetarianism, okay? So the first case involving Crossley Farms was someone who was a vegetarian. And he alleged that he had been discriminated on the grounds of this philosophical belief. He said it was genuinely held, it was worthy, philosophical, cogency, etc. But in the tribunal's view, vegetarianism was held not to be a philosophical belief. The reasoning was, and I think probably right, if I make the offhand mention to my own change of diet for a short period of time, it's a lifestyle choice. It's what the tribunal held at first instance. Vegetarianism is something that can be chosen. And what they did was they contrasted vegetarianism with veganism, which might, the tribunal said, have a stronger underlying cogency because it might link to other things people might have, not just health and diet, but animal welfare and personal taste not necessarily coming into it, might be much more stringent. So this is an ET case, as was the next one we'll look at. So not binding law, not appeal level, but fascinating, as I say, to see how interested the media were when these cases came on stream. So the one that I think got most press attention was, try and pronounce, Casamitiana against League Against Cruel Sports. Now the respondent maybe says a lot, doesn't it, the nature of what they do, the League Against Cruel Sports. But this case was widely reported, and this individual, the claimant, was an ethical vegan. So that's the language that was used here, ethical veganism, and again, whether that's protected. Now, this individual, quite extreme on the facts of how he lived his life as an ethical vegan. An entirely plant-based diet. He avoided all animal products, dairy, eggs, honey, meat, fish. He avoided any form of animal exploitation, buying or wearing clothes made from leather, wool. But I think probably most reported, he led evidence that he would rather walk than take a bus to avoid accidental crashes with insects and birds. So this individual, as I say, lived his life to protect the sanctity of life with animals. And lo and behold, look at the name of his employer who he chose to work for. Here the tribunal found, but I'll come back to that, I'll hesitate how I'll use that ethical veganism is protected as a philosophical belief. But the reason I hesitate there, despite the headlines, actually, what we found as we drilled in a little bit more in researching this case, the tribunal actually didn't make a finding of that nature. They didn't have to, because that employer, and perhaps again, given the nature of what they do, they abandoned the point. They didn't contest the point. They conceded that the claimant should be protected as a philosophical belief, being an ethical vegan. Okay, and furthermore, they didn't admit that they discriminated against him. They didn't hold their hands up and say we did anything. They just said, as a matter of principle, a jurisdiction point, if you like someone being disabled, they conceded it. They conceded ethical veganism. We'll give them that. We're not going to fight it. That's a philosophical belief. So, how much do we read into that, guys? I think on this one, it's relevant. It's probably right in terms of that nature of that case, and maybe going forward. I did a presentation on this where a number of employers took the view, well, God, where is this going to end? Because does that mean you need to provide vegan foods for people at work? And what if someone refuses to wear a uniform that has animal products? So it's definitely one to watch, and the direction of travel is, I'm afraid, very wide as it relates to giving protections for individuals on philosophical beliefs. Thanks. And Andrew, on sex discrimination next.
Thank you, David. So I'm going to cover a few areas here, and I will just try and rattle through them as I'm conscious of time. So in Ali and Capita Customer Management Limited, this was last year in the Court of Appeal, and the court held that the failure to match pay for shared parental leave to the level of enhanced maternity pay neither constituted direct nor indirect sex discrimination. So this was something that had attracted a lot of commentary when the shared parental leave rules came into force. Many employers offer enhanced maternity pay, but perhaps not enhanced shared parental leave, or not to the same level. And the question was, would this be either direct or indirect sex discrimination? The court held no. It held that there's a material difference between a man wishing to take shared parental leave and a female worker who is entitled to statutory maternity leave, such that she will not be an appropriate comparator for discrimination purposes. The court commented that a requirement to equalise payment for maternity leave and shared parental leave would eliminate the special treatment afforded to a woman in connection with pregnancy or childbirth, which would be contrary to public policy. An application for permission to appeal this decision was made to the Supreme Court, but that has now been refused, so we know where we stand now. In the absence of new legislation, shared parental leave doesn't need to be enhanced to match shared parental leave pay doesn't need to be enhanced to match enhanced maternity pay. So the decision obviously brings a degree of certainty for many employers, but I suspect will, at least in the immediate term, lead to a low uptake of shared parental leave. So just moving rapidly on then to the next set of cases, which touch upon disciplinary matters. The two cases referred to on the slide, which I'm going to try and wrap through quite quickly, demonstrate that an employer is unable to escape liability for unfair dismissal where information is withheld from the decision maker. So in the first case, Duty, the essential facts for our purposes were that Miss Duty had made protected disclosures under our whistleblowing legislation. Her line manager had then retaliated against her for doing this by placing her on an onerous and unfounded performance management plan, which eventually caused Miss Duty to be signed off sick with work-related stress. The performance process then passed to a different manager who decided that Miss Duty's employment should be terminated on grounds of her performance. And it's interesting to note Miss Duty was too ill to attend any meetings arranged to discuss her potential termination, so she was unable to make any representations, such as that she had made protected disclosures, and indeed the line manager buried that fact from the manager who dealt with the performance process. So the manager who took the decision to dismiss was actually unaware of the fact that protected disclosures had been made, and she took the decision based on her genuine belief in the poor performance reports which had been fabricated by the line manager. So the essential question for the tribunal was whether the reason for the dismissal could be held to be the protected disclosures, even though the dismissing manager had no knowledge of them. As you'll know, if the reason or the principal reason for the dismissal was held to be the protected disclosures, then the dismissal would be automatically unfair. So this case was appealed all the way up to the Supreme Court, and in November last year, it handed down its judgment. The court held that the reason operating in the mind of the line manager who had manipulated the dismissal could be attributed to the employer, even though the decision maker herself was unaware of the protected disclosures. So the fact that the decision maker was unaware of the protected disclosures wasn't a saving grace for the employer in that case. What do we take from this? Well, as the Supreme Court itself noted, the facts of the case were pretty extreme and perhaps unlikely to come up very frequently. Nonetheless, I think it's an important decision, and it serves as a reminder to employers of the importance of fully investigating and considering the employee's case before dismissal. And that's particularly so where the employee is unable to make proper representations due to their ill health. The second case, as I say, due to time constraints, I'm not going to go through the facts of Uden. Instead, I'm just going to summarize the main principles. So as we'll all be aware, for a dismissal to be fair, an employer has to show a fair reason for the dismissal, and also separately that it acted reasonably in treating that reason as sufficient to justify dismissal. So as I explained, in duty, the Supreme Court had held that an employer can be liable for the real reason for dismissal, hidden by the employee's line manager, regardless of whether the decision maker actually has knowledge of that. And Uden confirmed that this principle could apply to the second stage of the fairness test. So in Uden, it was accepted that the reason for dismissal was misconduct and so potentially fair. So the employer got over the first hurdle. They were able to demonstrate a potentially fair reason for dismissal. However, the investigation manager in this case had withheld important information from the disciplinary manager who took the decision to dismiss. And the investigation manager's knowledge and then failure to share that knowledge with the disciplinary chair was held to be relevant to the question of fairness. So I think the important lesson to take from this is that managers involved in any stage of a disciplinary process should be informed that any information they provide should be accurate and should remain accurate. And even if the process moves beyond their stage, so once the investigation's closed, it's vital that the investigation manager, if new information comes to light which he or she believes will impact on the disciplinary decision, that information needs to be on passed to those that are then involved in the process. And in this case, it was a case where the employee's reputation and ability to work was at stake. So this just underlined the importance of that. Okay, moving rapidly on then, I think to our final section in the case update. David, if you can skip forward on the slides, please. Excellent, thank you. So yes, to finish on a high note, a TUPE case. So as we all know, where there is a relevant business transfer or service provision change, TUPE can operate to transfer the employment of employees from the transferor to the transferee. So in a business transfer, a sale of a business from one company to another, TUPE can apply so that the employees of the seller transfer to the purchaser in very simple terms. And under TUPE, this right applies to employees. And the definition of employee under the TUPE regulations is an individual working under a contract of service or apprenticeship or otherwise, but excludes the self-employed. Now, in the case that was mentioned on the slide, Dewhurst, the Employment Tribunal held that this definition also captured workers, so that silver status that David referred to when he was on talking about worker status, that kind of middle category between employee at one extreme and self-employed. We have the middle ground of worker, which, as David mentioned, lots of the gig economy cases have found that those engaged in those types of activities are workers. So Dewhurst, the Employment Tribunal, held those workers would likewise transfer under TUPE, and there would be an obligation to inform and consult with them about the TUPE transfer as there would for employees. I think anyone involved in a TUPE transfer should be aware of this decision, but it's important to bear in mind it is a first instance decision only, which means it's not binding on other employment tribunals. However, no appeal has been lodged in the case, so it's one to bear in mind and risk assess when involved in a TUPE transfer. So that, I think, concludes the section on the case updates, and we're just going to move on to some developments in the legislation, and I'll hand back to David.
Thank you, Andrew. Thank you. I'll be very brief on this, on the Good Work Plan. It's probably the headline-grabbing stuff that we're looking forward to in the Good Work Plan really relates to the issue of clarity for employers and workers, which we still don't have. So all the Deliveroo, Uber, and other cases that are coming through, ultimately we are hoping for legislation rather than case law on those. But some reforms have already come into pass. I've pulled up on the slide, and I won't look at it in detail, but probably the key one, going back to Andrew's case update on holiday pay, we now have a reference period extension for holiday pay, not the 12 weeks under working time regs, but extended to 12 months, which I think was welcome. That was a welcome change in kind of smoothing out the average calculation for holiday pay over a 12-month period. And the other one, it wasn't great shakes, but it actually is important. It impacts on what you do for new employees. Written statements of terms and conditions of employment are a day one right now, and further detail has been provided. So we can help with that. Of interest, we're working with a number of clients for new starters post 6th of April, where you've got to have a look at your standard statement of terms and conditions of employment, and perhaps could be ripe for update. But I will skip on to the next section of legislative change, Andrew, on bereavement leave.
Thanks, David. And just seeing the time, I'm going to be brief on this as well. There's quite a bit of detail in the slide. This legislation came into force on the 6th of April 2020, and it provides a right in respect of a child under the age of 18 who dies on or after that date. It includes stillborn babies or a child lost to miscarriage on or after the 24th week of pregnancy. And it gives a right for parents, adoptive parents, parents-to-be, primary caregivers, or the partner of any of those to 2 weeks bereavement leave. This is a day one right, so parents are entitled to the time off as soon as they start employment, but they must have worked for their employer for at least 26 weeks to be entitled to receive statutory parental bereavement pay. Those who qualify for that, they get 2 weeks of paid leave, which can be taken any time within 56 weeks of the child's passing. And it's a fairly small statutory sum equivalent to statutory paternity pay, which is payable for that 2 week period, unless, of course, the employer decides to enhance that. So just skipping on from that, very brief to employer national insurance contributions. Again, a very brief but very important one. As you'll know, prior to the 6th of April 2020, certain payments made to employees for loss of office were exempt from income tax and national insurance contributions up to the value of 30k, and thereafter they would be subject to income tax only. From the 6th of April this year, the rules changed such that payments above the 30k threshold will, in addition to income tax, be subject to employers' national insurance contributions. So just to be clear, the exemption still applies to the first 30k if it qualifies, so you still are entitled to pay that without deduction of tax and national insurance contributions, but the excess above 30k has to now be taxed and employers, but not employees, national insurance contributions need to be paid on that. Okay, that then takes us on to some future changes, and I'm going to look again very briefly at some future legislative changes. So the first on the slide mentioned is IR35. Most of you will have been familiar with that. It was something that, the introduction of IR35 into the private sector caused quite a bit of stir, and we obviously worked with a number of clients on that, and also had briefings and training and the like, which you may have caught up with. Everyone will know that those rules were due to come into force in April this year. However, due to COVID-19, they've been delayed until April 2021. Just to brief flag very briefly, we're aware that the House of Lords has recently outlined its concerns about the 2021 rollout in a letter sent to the Treasury. So watch this space. That could mean further delays or changes are possible. Again, then just quickly rattling through the other things on the slide, the government has stated that it will protect and enhance workers' rights with a new employment bill, and I just wanted to highlight a number of the changes which are in the offing as a result. Again, very quickly, so intention to introduce a new statutory entitlement to neonatal leave, new statutory right to leave for unpaid caring, those engaged in unpaid caring responsibilities, and importantly here, the next one, an extension of the redundancy protection currently afforded to women on maternity leave is also on the agenda. So at the moment, as you'll know, a woman who is on maternity leave and who faces redundancy is entitled to be offered any suitable alternative vacancy, and that's it. In preference to any other employee who might also be facing redundancy. And the government has stated its intention to extend this protection so that it will apply not from the date that maternity leave starts, but from the date the employee notifies the employer in writing of her pregnancy, and it will extend to the date 6 months after her return from maternity leave. And I shall just move on from there as we're tight from time and pass back to David on some future case changes.
Yeah, just a couple of cases coming up to the Supreme Court that I think are worthy of mention, just to kind of have on your radar. The Uber case will hit the Supreme Court. Court of Appeal held they were workers, Uber drivers, but the final word and say will be with the Supreme Court. And finally, this one, Costal. You'll know it if you've come across it before. Section 145B of the Trade Union and Labour Relations Act of 92, pretty hideous cases, inducements to prevent people taking part in collective bargaining, and ultimately could be a penalty effectively of up to around £4,000, well, in fact, a mandatory award of £4,800, I think it now is, per individual. So we're working on a claim that's stopped in its tracks pending this decision of Costal at the Supreme Court. So watch this space. The Court of Appeal held that unions should not have a veto if you have exhausted collective bargaining and then you go direct to the workers to try and get them to change their terms and conditions. And we'll be very interested to see how the Supreme Court reacts. But for those of you who recognize a trade union, take great care in light of Costal before you go direct to employees to try to get them to change their T's and C's. So conscious of timing, but I don't know if those of you that were dialing in for a COVID update, we really don't have time to look at any detail. But if we're happy to, please feel free to dial off if you need to. But maybe spend a few minutes, Andrew, just to kind of sum up on the latest with furlough and all of that before we sign off.
Yes, no problem at all, David. So hopefully everyone's not bored of this by now. Obviously we've had a number of these types of sessions covering COVID-19, and I'm sure we will do, should there be, we will hold additional sessions should there be further changes. Just to kind of summarize where we are and the latest developments, which I'm sure will be familiar to most. It's obviously been announced that this scheme will continue for a period, and it's going to continue in its current form until the end of July. Thereafter, from August until October, Rishi Sunak has stated that the scheme will continue, but with greater flexibility to support a transition back to work. And crucially, he said that employers utilising the scheme from that point will be asked to share in its cost. So we are obviously all eagerly anticipating further detail of that, which we're told will be released later this month, because at this point we don't know how much of the cost employers will be asked to bear, and quite what the detail of the flexibility to allow those furloughed to also participate in work will be. So one to look out for, and I'm sure we will be publishing future updates when we get some more detail on that. Just a kind of couple of issues, I think, just to cover very briefly that are of interest here. Obviously, we will have all seen in the press the divergence in approaches between the UK government and the devolved governments in Scotland, Wales and Northern Ireland. So whilst in other parts of the UK the message remains stay at home, in England this has been changed to stay alert, and England has therefore seen a larger number of employees who cannot work from home return to the workplace. Just to flag, as we've done on the slides, that practical guidance was published on the 11th of May to help get people back to work safely. Very high level summary of some of the key points. Employers should carry out a COVID-19 risk assessment, and if possible, publish this on their website. Employers should, where possible, redesign workspaces to maintain 2-meter distances, and they can do this perhaps by staggering start times or changing workspace layouts. And then quite an obvious one, workplaces should also be cleaned more frequently. Just to pick up on then a couple of additional points there. Shielding employees, so those who are deemed to be most vulnerable to COVID-19 and would have received a letter advising them of that, are not expected to return to work under the guidance. For vulnerable employees, so those who fall short of the requirement to shield, if they can't work from home, then the guidance suggests that they should be offered the option of the safest available roles, trying to ensure that they stay 2 meters away from others. And if that's not possible, employers should carefully assess whether this involves an acceptable level of risk. Just to kind of final point on this, one that we've been asked about, throughout the furlough scheme. A question on the mind of many of employers is, who are perhaps envisaging that they will have to go through redundancies because the work is just not going to be there following the ending of the furlough scheme. The question is, can we consult during furlough, or would this be deemed to be work during furlough and thereby prohibited by the scheme? There's nothing specifically on this in the current guidance, but the guidance does make clear 2 points that are relevant. So firstly, whilst on furlough, employees who are union or non-union reps may undertake duties and activities for the purposes of individual or collective representation of workers. And secondly, the guidance from its inception has said that employees can still potentially be made redundant when on furlough. So whilst it doesn't specifically say that you can consult for redundancy purposes, I think we can glean from these 2 things that it's likely still to be possible. I appreciate, that's just a very brief summary of some of the more current issues involved in COVID-19 and the furlough scheme. And hopefully that's been of some assistance. As I say, we'll likely be publishing further updates and holding further sessions, so you'll no doubt receive invites to that. If I can just wrap up there by saying thanks very much to everyone for having dialed in and followed the guidance of staying on mute. And appreciate it might be preferable for everyone to chip in with questions, but just with these high volumes, it's not always practical. So thanks for those who submitted questions in writing as well. And hopefully we have covered at least in some detail the topics that you had hoped. And of course, David and my contact details are available on the screen there. So any follow-up questions that you have, feel free to drop one of us a line or whoever you would normally deal with in the employment team at Burness Paull. And without further ado, I'd just say thank you very much and have a great day, everyone. And we'll dial off there.
Thanks, everyone.